Recording. All right, good morning, everybody. I think we have one or two other attendees that are going to be that had registered, so we're going to wait just a moment before we dive in. But thank you for logging in today and having an interest in the topic that we have for our webinar today, which is estate planning for 30-somethings. I think it's really important for everybody to have an estate plan. So I think this is really good information for folks of all ages. So again, thank you for your interest in logging on. And if you have any just generally ideas for future webinars that you'd like to see from us, we'd be happy to have those ideas. We always like to tailor these presentations to topics that are of interest to folks. So if you do have topics that you'd like to see webinars on in the future, please email us through our website. And again, we'd be happy to have those items be addressed in upcoming webinars. We do also have all prior webinars that we've done so far through our Wednesday webinar series available on our website, or I should say a link to those prior webinars on our website. And we've done some prior webinars on some, at least I have specifically on general estate planning topics. So what are trusts? What is a will? What is incapacity planning? What is probate? So if you do have interest in some of those more general topics, again, please feel free to visit our website and you can click the links to those videos and view them at your leisure. All right, so in the interest of time, I think it's 12:02, so we'll get started. So as I mentioned, today's webinar is primarily focusing on the importance of estate planning for younger folks. There's the common misconception that estate planning is really something that's only for the elderly or something for the ultra wealthy to take care of. But really, again, estate planning makes sense for people of all ages. And actually, that's the purpose of the webinar today, is really to address those topics that specifically are going to impact, I say 30-somethings, but younger individuals who may be just starting out, just recently have gotten married or gotten that real important first job, started accumulating assets, or having kids. So as you kind of hit those major life events, again, a lot of the times that's when estate planning can make a whole lot more sense for you. So number one, what comes as probably no surprise to anybody, because it's the primary purpose of most estate plans, is directing where your assets are going to go. So when if you have a 401k, if you have bought your own home, you own your own car, I mean, these are all assets. So I know a lot of 30-somethings may also be carrying around a substantial amount of debt as well. So primarily student loan debt is one that's probably the most common. So they're typically not thinking of themselves as having a whole lot of assets, but you might be surprised at the assets that you do have that you've accumulated thus far. So it's still important to direct what's going to happen to those assets if something happens to you. So whether that be you'd like it to go to, if you're married, it should go to your spouse, for example, or if you have children, you say, it goes to my children. Or if you're not married and don't have kids, maybe it's directing it to pass to your parents or pass to siblings. Or maybe there's local charities that you really like to support. So it's really important to have all those wishes spelled out, because in absence of those written instructions, when you pass away, those assets are instead going to pass in accordance with the state's laws of intestacy, which are really just the default rules that say your assets go to next of kin. So it can be pretty simple. Again, in the situation, if you're married and you don't have any kids, assets, again, even if you don't have a will pass directly to your spouse. So if that's the result you want, then it works fine. It can get a little bit more complicated if you're married and have children, because the default rules in that case state that if the first $100,000 of your assets do go to your spouse, but if you have assets over that, again, the first 100,000 go to your spouse, but then the balance is going to be divided between your spouse and your children. So that's a result that may not sound all that great in practice, just because the one example I always give, if your primary asset is your house, and again, if that's something that's owned individually by you and not already joint with your spouse, When you pass away, the first $100,000 goes to your spouse, and then the balance gets divided 50-50. That could theoretically result in your spouse owning your house jointly with your minor children. So again, generally it sounds great. It all goes to my spouse, it all goes to my kids, but the specific way that plays out may not always achieve the exact result you're looking for. And again, not only can it be problematic with spouses and kids owning assets together, but particularly, again, minor kids. It can get tricky when you have a minor child inheriting assets and don't have specific plans in place for how those assets are to be managed. So again, a lot of times then it falls back on default rules that the state has written as to how those assets are to be managed. So the big takeaway is, if you don't want to just rely on the default rules, which may have some unintended consequences in terms of how your assets are going to be distributed, it makes a lot of sense just to spell out exactly what you want. And it doesn't have to be overly complicated. It doesn't need to be some big 30-page long will and trust or anything along those lines. It can be a pretty simple, straightforward document that says, here's my first choice. If I pass away, first it all goes to my spouse. If my spouse has passed, then it all goes to my kids. And you can kind of leave it at that. It doesn't need to be overly complicated. But again, simply having those directions written out can make things a whole lot simpler if something should happen to you. Similarly, one of the primary purposes of a will is going to be a guardian appointment for minor children. So again, even if, again, assets aren't the primary focus, if you say, you know, I have more debts than assets, there's really not going to be much left at the end of the day for me to pass along. A will is still going to make a lot of sense to you. So you say, well, if I do pass, and if my child's other parent has also passed, we want to choose who's actually looking after our kids from day to day. Who's going to be the person that we want making sure they get dressed in the morning and they're getting on the school bus, and they're doing their homework and going off to basketball practice at the end of the day, and taking them to games on the weekend, all those types of things. If you don't have those instructions specifically written out, again, in the will, somebody will still be appointed to be a guardian, obviously, but it's then up to the court to decide who that person is going to be. And it may still be the person that you always intended. Maybe it is your parents, or again, a sibling, the person that you would have wanted to be looking after your kids anyways, but there's no guarantee. It can sometimes end up as somewhat of a free-for-all, where anybody who says, I want to volunteer, petitions to the probate court to say, I'm the one that should be appointed. But then if you have multiple people saying they want to be appointed, it can cause a lot of family strife and confusion. People, going head to head in front of the probate court and saying, no, they always intended me to be the one looking after the kids, not you. Again, it can be a really problematic situation, because now, again, the court is left to sift through all that information and try to figure out what's best for your kids. So not only family infighting there is a potential issue, but even if it's really, there is only one person that petitions, so there's not people, again, that are fighting to get appointed, the person who's ultimately chosen could be very disruptive to the kid's life, simply in terms of geography. If it's your sister or your brother who lives out in California that's appointed as the guardian, but the kids live here in Connecticut, you are now having those kids be uprooted, moving all the way across the country, away from other friends and family members that they've known their whole lives, simply because the person that's being appointed doesn't live here. So it's really, a lot of factors can play into, one, where the kids are going to end up, but it's really a judge at the end of the day is going to try to have to guess what's best for the kids, not knowing really the kids and not knowing your family dynamics necessarily. So again, the more instructions you can spell out and write out in advance, it's going to eliminate that guesswork. And you say, you know what, even though I may not have any assets passing under my will, I still want to have one, because again, simply if something happens to me and to the kids' other biological parent, my spouse, or again, whomever it might be, I want to make sure the people who I want are managing the kid or looking after the kids are actually the ones that are going to be appointed to do that. Also, something that is an option too for a lot of parents, and this is something that's not necessarily on a permanent basis, but it's meant to be kind of a temporary situation, is what we call a standby guardian appointment. So if you are going to be traveling and away from the kids for a prolonged period of time, or if God forbid you should have an illness that really prevents you again from handling the day-to-day things and making decisions on your kids' behalf, you can appoint someone to temporarily take over that role. And again, manage the kids' care and talk to their doctors. And, if your kid falls off the playscape and breaks their arm and you're out of town, again, this document can appoint someone that can take them to the ER and make medical decisions for them again, and make sure they're going to get the care they need, even though you may not be able to physically be there and do those types of things for yourself. So again, there's a lot of planning that can come into play, not only under your will, but again, also during your lifetime with these types of guardian appointments for your kids. Also important to know that I've talked a lot about the will directing what's going to happen to assets upon your passing, but it's also important to know not everything that you own is going to pass under your will. So there's certain categories of assets that are going to pass outside of your will, because the only assets that go under your will are assets that need to go through probate. And the only assets that need to go through probate, to kind of back up one step further, are assets that are individually owned by you. So, for example, if you own your car in your own name, or if you bought a house and you're the only person on the deed, those are the types of assets that are going to go through probate when you pass away, because they're solely owned by you. Assets like life insurance or retirement accounts like a 401k and IRA, those types of assets are set up by default to have beneficiary designations on them. So when you set up those accounts, you have the option to fill out that form that says, when I die, the money goes to John Smith, it goes to my mom, it goes to my dad, it goes to my siblings. Again, you can choose who that beneficiary is going to be to receive those assets. So it's important to know, not only when we talk about estate planning, yes, is a will important to direct assets? Absolutely. But you should also do some homework to figure out, well, do I have assets that are passing through beneficiary designation? And making sure those beneficiary designation forms are filled out, and designate the appropriate people to receive those assets if you do pass away. Also, and this is something that applies to estate planning in general, it's not something that should be done once and then you never do it again. So you shouldn't do a will and then not touch it for 50 years, because obviously life is going to change. So your instructions likely are going to change with it. Same rule also applies to beneficiary designation. I find it's very common for folks, particularly when you're in your 20s and your 30s and you're just starting out and you get that first job that comes with the 401k. Well, at that time, maybe you weren't married and didn't have kids. So one, maybe you didn't fill out that form, that beneficiary designation form at all. Or if you did, maybe you named your parents as the primary beneficiary on that account. 5 or 10 years later, now you're married, you do have kids, or you have other important people in your life that you want to leave those assets to. You need to remember to go back and revisit those beneficiary designation forms and update it to name the people that you now actually want to receive those assets. So again, it's important to make sure you have those beneficiary designation forms filled out. But again, periodically review them to make sure they're still correct. So my default is every 2 or 3 years, double check to see who you have named as beneficiaries on various accounts. So again, life insurance and retirement accounts tend to be the most common. But it can also be investment accounts or bank, just regular checking and savings accounts, kind of any financial account. Typically, you have the ability to name a beneficiary designation on those. So to the extent you do, again, every 2 or 3 years, you should be double checking those to make sure you're still naming the appropriate people as the beneficiaries to receive those assets. Again, and a lot of my apologies for the attendees out there who don't have minor children, but again, I'm going to address another topic specific to folks who do have younger kids. Well, great. You said, I definitely, if something happens to me, I want my spouse maybe to get those assets first. If my spouse has passed too, then I want the assets to go to my kids. And again, that's a very common setup and probably is going to achieve pretty much the result you want. But again, what happens if your kids are younger and there's going to be receiving some type of inheritance? Legally speaking, persons under the age of 18 can't legally own assets. So one, they're not going to be able to just, get those assets outright. There's going to be someone that's going to need to be put in a place to manage those assets for them at a baseline until they at least reach age 18. But even with that, how comfortable do you feel at the thought of an 18-year-old inheriting your house or inheriting your 401k or $100,000 through a life insurance policy? if that maybe gives you a little bit of apprehension of thought of just a big pile of money falling into a kid's lap, then maybe it's not as simple as just saying, I name my kid as the beneficiary, because you really don't want a young kid like that to inherit a bunch of money. Again, even if they are legally able to own it, their first call might not be to the financial advisor. So to prevent them from just running off and buying the Lamborghini, and making sure those funds are really preserved in the way that you intended to last them through at least a good chunk, if not all of their life, make sure it's managed appropriately. Maybe now you're considering, instead of leaving those assets to your child outright, is leaving it to your child in trust. And the trust is going to allow you to set the rules for really how you want that inheritance for your child to be managed. So if you say, regardless of whenever it is that I passed away, maybe I never intended the kids to get these assets until they were 21, until they were 25 or 30, or again, kind of whatever that age is that says, okay, by that point, I feel comfortable at the thought of them inheriting assets outright. So that's the role that the trust will serve. It'll say that if you pass away and they're under the age that you've chosen, that instead of getting those assets outright, they will be held in trust to be managed by a trustee. So that's also someone you get to choose. So you get to pick who's in charge. And then those funds will still be available for your kids. So the trustee can still use those funds to pay for college or to help them buy a car. Or heck, if the kid says, I want to take a weekend trip to Vermont with my buddies, if the trustee says, yes, that's appropriate, the trustee has the discretion to really make those distributions to the kids for whatever the trustee deems to be appropriate. So the kids will still have access to their inheritance, but just through a buffer, so to speak, a gatekeeper. That trustee is still going to make sure those funds are managed appropriately, distributions only being made for purposes that you probably had intended. And then once the kids reach that age that you've designated, so again, 25 or 30 or whatever age that is, that's when the trust will terminate and the kids will receive their inheritance outright. But again, in the meantime, they'll have the assistance of that trustee, making sure those assets are really managed appropriately for them. So again, trust can be really provide a lot of peace of mind for parents with younger kids, because again, even if kids are legal adults, as they get older and they turn 18, a large inheritance can be tricky to manage. So trust can provide a lot of benefit. Also, too, for kids that may have some form of disability. So, for example, if your child has some type of medical issue, maybe they're receiving their health care or their health insurance through the state, through the Medicaid program. There are also specific types of trusts you can leave assets, again, still to be available for the kids and to be managed by a trustee, but also structured in such a way that's not going to jeopardize their continued eligibility for those benefit programs. So again, trust can provide a lot of benefit depending on your situation. Also, something that most 30-year-olds don't like to think about is incapacity planning. I'm in my 30s. I think the likelihood of me developing a really severe illness or having some type of accident that leaves me incapacitated and unable to manage my affairs is probably fairly low. The younger we are, the more invincible we tend to think we are as well. So we think those types of occurrences are probably unlikely. But it does happen. I mean, these illnesses, accidents strike people of all ages, from all walks of life. So to have some form of incapacity plan in place for if something happens to you, the will cover what happens to your things, or trust can have what's going to happen to your things if you die. But if you don't die and you just really need help on a day-to-day, these incapacity planning documents that I'm going to briefly describe next are what's going to help you in those events. And really the two primary documents that fall under that umbrella, the incapacity planning umbrella, are powers of attorney and healthcare directives. So with the power of attorney, you're choosing someone that'll have the legal authority to assist you with your assets. Someone that's going to be able to have access to your bank accounts, to sign your checks, to file your tax returns, to help you register your car with the DMV. Someone that, again, that's really going to be able to stand in your shoes and help you manage your assets the same way you were able to. That's the function of the power of attorney. The healthcare directive, as the name implies, is the medical side of the coin. So if you need someone to communicate with doctors and decide on courses of treatment, and you're unable to communicate those wishes for yourself, the healthcare directive is the document you use to appoint the person who's going to be your medical decision maker, and again, doing those things on your behalf. Something that can go hand in hand too with the healthcare directive is a living will. And despite the name, it has nothing to do with the passage of your assets. So there's the last will and testament that provides the instructions for what's happening to assets. The living will, again, kind of goes more along the lines with the healthcare directive, because what it does is it states that if you're at end of life, if you really have a terminal illness or some type of medical condition from which the doctors do not expect you to recover from, it states you don't want extraordinary measures taken to save your life. So you don't just want to be kept alive by machines. Again, if you have no expectation that you're going to recover. One of the distinctions I do like to make specifically with the living will, in light of the current COVID climate and people going on respirators and ventilators, the living will does not apply if the doctors expect you to recover. So if you have COVID and you're in the hospital and the doctors want to put you on a ventilator, but then they think in a week or two or whatever time period it is that you're going to recover and come off that ventilator, they're not looking at your living will. Because again, that living will only applies if they do not expect you to recover from the medical condition that you have. So again, if doctors think they need to take some action just in the short term and they think you'll improve, they're not looking at your living will. So I know that's a concern for a lot of folks, basically thinking that, well, if I have a living will, then the doctors aren't going to try to save me. And again, that's really not the intent. So I do like to just clarify that point. Last but not least, one of the things that also, particularly with folks in their 30s or younger, or again in their 40s and such, is we as a culture have started to develop more of an online presence. We do online banking, we have social media sites. You may even have digital assets like cryptocurrency, Bitcoin, and all its subsequent successors. So if you have assets like that, it's also important to make sure you make a plan for what's going to happen to those accounts and to those types of assets. One of the big one we see from a day-to-day is email. A lot of people are getting bills emailed to them versus paper statements in the mail, or they pay their bills and do banking online. And if you're unable to, again, if you should pass away or if you become incapacitated, someone else is still going to need to pay those bills and still need to manage those accounts. So at the very least, it makes a lot of sense in my experience to have to have the power of attorney documents. So you say you do appoint someone to be able to manage all your assets. And our power of attorney form even specifically includes digital assets. So we say specifically your agent under power of attorney is going to be able to have, you want them to have access to email and online banking. But more practically, just to have a list of usernames and passwords for those most important sites that you use that, again, are going to be really invaluable for anyone who's going to have to step in and help, is a really good idea. Not that you should have this list and hand it over to folks, but again, maybe just have it written out, have it saved somewhere on the computer. So if somebody does need that information, they simply know, I know where Allison keeps her list of important passwords. So I know where I need to go if for whatever reason I need to step in and help. So again, so more and more that's becoming an issue, because in even 8 years ago or so when I started practicing, one of our primary pieces of advice we would give to people who are helping after, somebody passed away, after mom or dad passed, and now they have to settle their estate and pay all mom and dad's bills. Our primary piece of advice is to say, well, if you don't know what bills they have, just watch the mailbox, because those statements are going to be coming in the mail. But again, these days now those statements and those bills are coming through email. So we can't necessarily just tell folks to check the mailbox anymore. We have to make sure they're checking all avenues of communication, specifically including those email accounts. So to make sure people are going to have access to those accounts is really important. So again, you can make a list of those passwords. Specifically, I know with Gmail, they have something that's called an inactive account manager. So if you go into your settings, you can say if my account is inactive for a certain period of time. I think when I had gone in and set it up for myself, I'd set it for 6 months. If nothing's happened on my account for 6 months, I want them to send an email to the person that I've designated and give them access to my account. So that way, again, it's another way to grant access to somebody. And I think for social media sites, Facebook and Twitter and Instagram, they have similar features, which are going to allow people to have access to those social media sites. And as silly as it sounds, you know, you may not be thinking that's all that important, but for a lot of people that I talk with that are focused on those types of accounts, it's because there's a lot of family photos on there. You post pictures of yourself and of your kids and of your family. So for no other reason, to allow people, you know, your loved ones to have access to those accounts, to have copies of those photographs, or maybe even some nice conversations that you had. And maybe they want to keep that for sentimental reasons. It still makes sense to go into the account settings. There's ways that you can allow certain people access to those types of social media accounts as well, because again, that might be important to you too. So that's my guidance for estate planning for 30 somethings. Again, the big takeaway is you don't have to have millions of dollars in the bank for estate planning to make sense. It really makes sense for everybody. I acknowledge that I'm biased when I make that statement just because of that's what I do for a living. But again, if you're young, if you have a certain amount of really any assets, you're going to want to make sure you set instructions for where those go. If you have minor kids, you're going to want to make sure you're including some kind of guardian appointment, and maybe providing instructions for how you want their inheritances managed. So it's just really important to plan. The more you plan now, the easier it's going to be for those if something does happen to you. And also too, you could, even if you put a plan in place to say, well, I just want to get something in place. I think it makes a lot of sense to plan with the knowledge of that down the road as your life changes, you can update. And if you already have the primary documents in place, so if you already have your wills and powers of attorney, update down the road to you know, name different people or maybe move around beneficiaries are not going to be overly complicated just because you already did a lot of the groundwork by setting up the documents initially. So this is the time where I like to give people the opportunity to ask questions. So if you do have any specific questions you'd like me to answer, please feel free to type them into the chat. And while I'm waiting to see if any questions come in, this is also, as I mentioned, an ongoing webinar series. So if you have any interest in upcoming webinars, please take a look at our website. I know the next one we have coming up in a couple of weeks is somewhat of a niche topic. We have estate planning for agricultural workers. So basically estate planning for farmers. So if that's any interest, please tune in. But again, we will have some other topics as well coming up. So please check our website for those new webinars that'll be coming down in the next couple of weeks. And also, again, check our website for webinars that we've hosted in the past that have some really good information on there. So basically, if you have any questions, if you have any other information that you want to obtain, you can always feel free to check out our website. All right, so I don't see any questions coming in. So again, thank you for everybody who signed on today. If you do have any follow-up questions, in addition to, again, looking on our website, you can always email. My contact information is on our website as well. So please feel free to email me directly, either with specific questions, or again, if you have recommendations for future webinars you'd like to see, we'd love to have that information from you as well. So thank you to everyone and stay tuned for future webinars.